Good evening. Good evening. This meeting will come to order. This is the May 2016 Zoning Board of Appeals. Please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
May we have roll call, please?
We've been advised that Ms. Eggleston and Mr. Thomas are out tonight. Mr. Chizola,
Here.
Mr. Haberman,
Here.
Ms. Ferrante,
Here.
Mr. Soda,
Here.
Mr. Vicino,
Here.
Mr. Dubois.
Here.
Thank you.
Thank you. Also present is Meg Green, our recording secretary, and Stephen Harris, our zoning officer. If anyone feels that there's a member on this commission that might be a conflict of interest to their application, please let us know. Mr. Haberman. Oh, let's see.
Do you want to mention?
Before we get started, item number 3 on the agenda this evening, 255 West River Street. The appeal has been withdrawn per attorney Danielle Berkery. Item number 4, 62 Hawley Avenue, is tabled till June. So with that, Mr. Haberman, item number 1.
Item number 1, 6 Silver Street, R5, Thomas Lynch Esquire, for William Ziebel, appellant, reference property owner, R. Poxon, Section 9-2-1, appeal the decision of the Director of Land Use regarding permit Z15798, map 27, block 454, parcel 4 and 5.
Good evening, Mr. Chairman. Again, for the record, my name is Thomas Lynch, and I'm an attorney with the law firm of Lynch, Trimbicki, and Boynton, and my office is located here in Milford at 63 Cherry Street. And as you know, I made a presentation at your last meeting on behalf of my clients, the Ziebels. I stand by the comments that I made. I'd ask that the minutes and all of the comments that were made at that meeting be incorporated by reference as part of the minutes of this meeting. And I believe that Attorney Crusade is here to add some additional comments. The hearing was kept open, so I'll turn it over to him and reserve the right to make any rebuttal comments if necessary at the conclusion of any statements he would want to make to you.
Okay. Thank you, Attorney Lynch. Go ahead, Mr. Crusade.
Good evening, Mr. Chair, members of the board. My name is Kevin Crusade, and my office is at 26 Cherry Street, law firm of Carroll, Crusade, and Moore. That's here in Milford. I think that you probably also want to hear from the Director of Permitting and Land Use, Mr. Griffith, but I would like to be heard very briefly on a jurisdictional issue. And if I could approach, I have some documents I'd like to hand out to the board. I have comments also about the substance of this matter, but I wanted to turn your attention to what starts at the third page in. The point of this is that it's our position that the appeal was filed too late. I know Mr. Lynch has a different opinion of that, obviously. I had the same different opinion that Mr. Lynch had in December of 2008 when I was before this board, and I had filed on behalf of my client an appeal that was a few days late. So I highlighted the comments in here because I had stated at that time that the state statute, upon actual notice received, that the 15-day appeal period begins. But if you turn to the second page of those minutes, we have comments from Ms. Stock at the time, who said it's been done that way for 30 years, and this is the way it is. We have comments from the Chairman Caton or Catan at the time, from Mr. Mead, Mr. Stock, Mr. Haberman was here, and as part of that. And at that time, my client was denied a hearing because the board decided that they were going to stick to their 30-year practice of a 15-day appeal period from the date of the notice. So in this case, the permit was issued, I believe, March 3rd, and the appeal was not filed, if you look to the second page of the package I handed to you, until March 21st. So I just wanted to, before we got any further into the merits of the case, I wanted to highlight to the board our position. If you read through these minutes, the board took they said, this is what our position's always been. It's 15 days from the date of, regardless of what the state statute says and regardless of whether the person had actual or constructive notice. So I leave that, I think that decision should be decided before you go any further tonight. But I do have additional comments on the merits after Mr. Griffith presents his case.
If I could specifically rebut that prior to you making a decision on that issue.
Go ahead.
Okay.
Yes.
So Attorney Crusading gave you the minutes, apparently, of a prior meeting of this board where that issue came up. And that may be all well and good, but the law is the law. And unfortunately for the position that Mr. Crusading has taken, our Supreme Court of the state of Connecticut addressed this specific issue in actually the precursor case to the Monroe case that I gave to you in my handout last week. And I have a copy of the precursor case, which is Monroe versus the Zoning Board of Appeals of the town of Brantford. It's a case that was decided by our Supreme Court, not a superior court, not the appellate court, but our state Supreme Court, our highest court. And in a decision that was rendered on August 6th of 2002, published and written by Tycho Sullivan, who was our chief judge at the time, the issue prior to the presentation of the second case, which was the merits as to whether or not the zoning enforcement officer of the town of Brantford had the authority to issue the permit that we all talked about in last month's meeting and the case of Monroe that's in your prior handout. But a preliminary issue was raised and appealed and went to the state Supreme Court on exactly the issue that Mr. Crusading has raised, i.e., in this case, the issue was whether or not the appeal period, and in Brantford I think it was 30 days, our regulations calls for 15 days. But the issue was as to whether or not the appeal period runs from the date that the permit is issued, which is the position that Mr. Crusading just offered to you, or the date that the person who files the appeal, which is my client, Mr. Zeeble, receives what's called constructive notice. So in other words, Mr. Harris, Mr. Griffith can sign a permit in the Parsons building, and whoever gets the permit can just sit on it for 15 days and then go out and start work. And what this case says is, unless you publish notice of the permit being issued in the legal notices of the newspaper, okay? Unless you publish a notice of that, this case held that the date tolls from constructive notice. And my client filed this appeal on March 21st. That was the day after he had spoken to Mr. Paxton, who's the builder on this property. Mr. Paxton showed up and had materials and started going to work on the house. And Skip came out and said, "What's going on?" And he goes, "Well, I got a permit from the building department. I'm going to put a second floor on this house." So Skip ran down, saw Meg, got an application to appeal the decision of Joe after he found out that Joe had signed the permit for the structure. And this case, and I'm submitting it to you, I've highlighted sections of it, so if you want to pass it around, that's fine. But the court specifically held, and on page 3 of the decision, the court says, In accordance with this principle, we adopt the interpretation of 8-7 urged by the plaintiffs and hold that under that provision, Section 8-7 of our statutes that says that not only someone can appeal to you for a variance, but they can also appeal the decision of a zoning enforcement officer. In accordance with this principle, we adopt the interpretation of Section 8-7 urged by the plaintiffs and hold that under that provision, an appeal may be taken to the Zoning Board of Appeals by any aggrieved party, the abutting property owner, during a period established by a rule of the board, our regulations say 15 days, or if no such rule is established, within 30 days of notice, and then goes on to say further on that that runs from the constructive notice. In other words, from the date that he receives constructive notice, he finds out that the permit's been issued. So I'm going to enter this case as part of the record, and unfortunately, I take dispute with Mr. Crusaden's position. We take the position that this case holds that you have 15 days to appeal the issuance of the permit by the zoning enforcement officer from the date that you receive notice of it, unless the party has published in the newspaper the fact that he has received that permit. So I'd like to submit this for the record.
Just briefly in reply, I made that exact same argument on December 9th, 2008, and probably cited the exact same case. I referenced a Supreme Court case. These aren't exact word-by-word minutes. These are summary minutes. And the board at that point in time decided that it was the policy going back to 1977. It's 15 days from the date the decision or the notice is sent. There's no other discussion about it. Like I said, I think that the critical point here is consistency with the board's decision and when the appeal period expires. Thank you.
Thank you. Attorney Crusaden, we have a question for you. Mr. Soda.
Attorney Crusaden, you said 15 days from the date of the notice. Mm-hmm. What do you mean the notice?
Well, that was in that particular case. There was a notice mailed, dated, I think, October 24th, 2008. We applied sometime in November. We filed the appeal sometime in November. But the regulation, I think it's section 9.2 of the Milford zoning regulations, say 15 days from the date of the decision, notice, or order. I believe that's the language.
Okay, so let me ask you this. If somebody comes in for an over-the-counter permit and gets a permit and doesn't start work, how do the neighbors notified of work going to be done? As if they're taking a variance, all the neighbors get sent a notice so they know. Now, in this case, nobody knew that work was going on until work started.
Well, it is an issue, and that was this board's policy since 1977. Typically, what I advise my clients to do is publish a notice in the newspaper so that we don't have this issue of non-notice, because it's
Publish notice for a regular building permit?
I recommend that if somebody believes it's going to be an issue. Yes.
Any other questions? Okay, thank you. Yes, Mr. Griffith. At our last meeting, Stephen Harris, our zoning officer, read a statement that you had given him. So the reason we left the hearing open was we did have some questions, and you're here this evening to answer those questions for us. Thank you.
Thanks. I guess before I start with my presentation, I did want to clarify. There is no building permit that's been issued for 6 Silver Street yet. He's got a zoning permit. That zoning permit was issued, I believe, back in March. That's what's under question. The building permit is still under consideration. There are some issues, not surprisingly, regarding how close you're building to the property line and the building code requirements. And I would note that, I'll guess 95% of the zoning permit applications that are approved are not approved for building permit within 15 days. Oftentimes, the building code allows once a zoning permit's been issued, the building code will allow up to 30 days for us to reject the applications, to reject the documents, which often is the case. So I'd just like to note that there is that distinction between the time that a zoning permit's issued and the time that somebody's out there starting to drive nails and when the neighbors would actually start to notice that something's happening there. You want to, or I guess, can I keep going then?
Yes, would you please identify yourself for people
Yes.
who might not know you? And
Sorry. Yeah, my name is Joe Griffith, and I am the Director of the Department of Permitting and Land Use. I was hired back in June of 2013 by the City of Milford as the Executive Director of the Department of Permitting and Land Use. And then in September of 2013, I was then made the chief building the building official for the City of Milford, working with the Chief Building Inspector, then Tom Rauchi. In February of 2014, through a memorandum by the mayor.
I'm sorry, Mr. Chairman. I don't mean to interrupt, but if Mr. Griffith's going to go into the merits of the case, I think the jurisdictional issue should be decided before we get into that.
yeah, that's not what's that issue right now? You're up, sir. You're up, sir. Go ahead.
Okay, thank you. As I said, in February of 2014, I was then appointed as the Chief Zoning Enforcement Officer for the city by the mayor, in charge with supervising, administering, and being responsible for the zoning decisions of the zoning enforcement officer, as well as the then assistant city planner and the city planner. And then finally, in July of 2014, I was appointed by the mayor as the floodplain administrator, and that responsibility charged me with making sure that the floodplain regulations for the city that were required by both our zoning regulations and our building code were properly administered in compliance with the FEMA requirements. And I just note that as Chief Zoning Enforcement Officer and as a city building official in the past 2 years, I've continued to rely on the expertise and the experience and frankly, the good professionalism of both Stephen, our zoning enforcement officer, and for a time, Tom Rauchi, and now Charlie Carell, the chief building inspector. So again, I'm not looking to do this on my own. I am looking to, in this case for Stephen, for a great deal of help, and I do consult with Stephen on any number of issues, and most of that is done through email. We leave a good, thorough paper trail of any discussions that we have, as Stephen will painfully attest to. Note that there are specific tasks that both through the building and zoning that through either state statute or good practice receive my direct approval and signature, and that's and I'd note that so that when we specifically when Stephen, as zoning enforcement officer, is reviewing an application, a set of plans or drawings that have come into his office, he would be issuing the zoning permit. And when that zoning permit is then printed out, it's printed with my signature on it as Chief Zoning Enforcement Officer. Similarly, when a certificate of zoning compliance is issued, Stephen is doing the field inspection, Stephen is doing the review of the construction documents and the files that have been submitted, and based on Stephen's recommendation and approval through our database, through View Permit, he notes his approval for that certificate of zoning compliance, and then again, it's my signature that shows up on the both the CZC and the certificate of occupancy. I've been invited here tonight to discuss the appeal that has been made by the our zoning office's issuance of building permit Z15-798. And the best I can tell, I watched Attorney Lynch's presentation from last month's meeting, the video of it, and I guess we're specifically focusing in on the regulations for 6.2.1 for extension, enlargement, and alteration of a non-conforming use, and the extension, enlargement of a non-conforming structure under Milford zoning regulations 6.3.2. Attorney Lynch has already read these regulations, but I think it's important to review them again, just because there are some key points that I think need to be noted. They're not in here. Under 6.2.1 of the regulations for nonconforming uses, it's important to note that the provision that Tom did read into the record last month, but this exempts single-family residences. It goes into pretty explicit detail, and I'm sorry I don't have the text in front of me here, but do you have that? Thank you. No nonconforming use of land shall be enlarged, extended, or altered. No structure or part thereof devoted to a nonconforming use shall be enlarged, extended, constructed, reconstructed, or structurally altered, except the change of use to one that is allowed in the zoning districts in which such use is located. This is the important part, except in the case of a single-family home. And then it goes on, no nonconforming use of a structure that shall be extended to occupy land outside such structures or space or other structure. And again, I read these as I do with all codes and regulations. I read the entire sections and take them very literally. The other provision, 6.3.2, talks about the enlargement and extension of or alteration of nonconforming structures. And that specifically reads, structures failing to meet any of the requirements of these regulations other than use, including the lack of required parking or loading spaces, shall not be enlarged, extended, or altered if the result would be an increase in the nonconformity. And again, we have read that, and when I say we've read that, we've reviewed it at length with the city attorney's office. They have come back to us with their verbal confirmation. My understanding is past zoning enforcement officers have reviewed that. As well as I cite a couple of examples tonight, which I'll go into, in which our office has looked at examples in which a non-conforming structure is being altered or enlarged, and so long as, say, for instance, the 3.5-foot non-conforming setback is not not decreased. So in other words, the existing structure has a 3.5 foot setback on the side yard. And when the construction is finished, the 3.5 foot setback on the side yard remains the same. We've complied with that section. So again, when we specifically looked at 6 Silver Street, their alteration and addition allowed them to go straight up, or proposed that they go straight up, and therefore the setbacks that were existing and non-conforming would remain the same setbacks. And as such, we viewed that as being compliant with 6.3.2. As I said, we've reviewed that in numerous cases with the city attorney, and they've agreed with our interpretation. And we have reviewed previous files and found it's consistent with other records. I guess I'd like to note one other thing before I go on and talk about the case here. Attorney Lynch was making reference to Monroe versus Branford, and a couple of points. It's my understanding that when questions of case law are brought before this or other commissions, the question as to whether or how that case is applicable to this particular issue would get referred to the city attorney's office, and their response and opinion would be then brought back to this commission in terms of the appropriateness of the application or the correlation of that case to the application. The other thing I would note, Attorney Lynch in his presentation last month repeatedly made assertions that the Branford versus Monroe case, or the Branford zoning regulations that were the subject of the Branford or Monroe versus Branford case were exactly the same as Milford's. And there's a really big difference in the two regulations, which I reviewed. Branford takes under, I believe it's section 5.1 of their zoning regulations, They take questions of nonconforming use and nonconforming structures, and they deal with them in the same provision. And so they lump the two. They don't distinguish between nonconforming use and nonconforming structure. Milford has dealt with them completely separately. Nonconforming use is under Section 6.2, and nonconforming structures under Section 6.3. And so again, we look at both of those, and in any particular application, including 6 Silver Street, look at its conformance with either of those regulations or both of those regulations. And so again, I don't want to go too far into questions about Monroe versus Branford, because it's my understanding that the city attorney should and will weigh in on its appropriateness to this issue. The review of the 6 Silver Street application, as I indicated to you in my memorandum last month, we viewed it with 2 respects. One is that under 6.2.1, it is a single-family residence. I know it's purportedly one of 2 single-family residences on the lot. We've had questions come into our office as to, we have 2 residences on a lot, which one's the non-conforming one? There have been clear cases where recently we've issued zoning permits for, I believe it is, I got too many papers here. We issued a zoning permit for, I believe it was, excuse me. To Scott Street, in which they had an existing, let's call it a main dwelling, and then also a concrete block building in which it clearly started out as an accessory structure, a garage. At some point, and without a permit, it transformed itself into an apartment. However, both buildings were in the flood zone. Both buildings were required to be brought into compliance with the FEMA requirements. And what we reviewed and documented was that the single-family residence, the original single-family residence, would be given a permit to be elevated and renovated, and actually in this case demolished and reconstructed in the same location. And the second concrete block building would not receive any permits until it was brought into compliance with the use. So again, we made that distinction on that site. Regarding section 6.3.2, the extension of a non-conforming structure, the enlargement of a non-conforming structure, again, our rationale was clear that the proposed addition to the building would not change the nonconformity. The existing nonconforming setback would remain the same when the construction was completed. As I said, this is consistent with a number of historic permits, legacy permits. I'll just note a couple of them. One is 10 Silver Street, just down the way in and again, I say this because historically, in 1993, a building permit was issued for that structure. It was non-conforming. The side yard setbacks were 9.6 feet, and they were given a permit to add a second story directly on top, extending that footprint straight up. More recently, in 2013, at 10 Silver Street, permit number B1461 was issued to allow for a second-story structure on an existing building. And in this case, the second-story structure was actually extending the existing overhang, which encroached into the setback. Again, we reviewed that. They were signed off by the zoning enforcement officer as compliant with no zoning board of appeals mentioned. I'd also like to note that in this particular application on 6 Silver Street, our regulations have changed, specifically regarding the enlargement of a building that's non-conforming, but allow its height to increase. And without reading the regulations verbatim to you, revised section 4.1.4.3, which took effect September 6, 2013, reads, notwithstanding the provisions of Article 6, Section 6.3 of the regulations, a zoning permit may be issued to allow the height of an existing dwelling in an area regulated under the provisions of 5.9 flood hazard and flood hazard damage prevention to be increased along with the minimal stairway and landing extensions when said dwelling does not conform to the required yards caused by the adoption of zoning regulations subsequent to the dwelling's construction. However, such dwelling may not be relocated on the lot without a variance if required. The building height shall follow the height regulations of the applicable area. I'd note that the previous regulations made specific reference to the requirement for elevating the building, whereas the new regulations just allow its height to be increased without distinguishing between a second-story addition or the space underneath the building due to its being elevated. So in looking at that regulation, I believe we were required to issue the zoning permit for this specific application. I guess that's my summary, and if you have any questions, I'd be happy to answer them.
Can I ask you again, on Silver Street, you cited two examples, the same situation that they raised the house, but they did not extend anywhere on the foot.
If I correct me, 17 Silver Street, which was done in '93, I was kind of furrowing my brow because it looked to be a substantial improvement, and under the regulations probably should have been elevated, but actually it was just issued a building permit to put on the second story only. But I'm sorry, go ahead.
So there was two examples on that street that they did add to the house, but it was just straight up.
Yes.
Any other questions for Mr. Griffin? No? Thank you. Mr. Lynch? Mr. Crusaden, do you have anything to say?
Yeah, sorry, thank you.
Yes, Mr. Chairman, Kevin Crusaden. Just briefly, Mr. Griffith highlighted a lot of the regulations I was going to go over tonight. I just wanted to point out, if you have that handout from the very beginning, because it appears to me that part of this appeal is that the Director of Permitting and Land Use does not have the authority to issue a permit. That's what it looks like. One of the claims is, as I understand them. So if you look at the very first page, from February 5th, 2014, you have the appointment of from Mayor Blake appointing Joe Griffith as the Chief Zoning Enforcement Officer, and he references certain zoning regulations. So I wanted to make that clear that he has been appointed by the mayor as the Chief Zoning Enforcement Officer, and as such, he can issue permits. I wanted to also point out, it was already filed on the record, and it looks like it was talked about briefly the last time Mr. Lynch was here. I have a section of the tax assessor's map which shows this as two separate tax parcels. I don't know what that means. I don't know exactly why it's two separate tax parcels. I don't know if that's because it's the buildings, but until recently, and then if you see an email from Dan Thomas, who's the Milford tax assessor, to Stephen Harris in December 29th of 2015, they talk about making that correction. I don't know what prompted that. My point being is that when these buildings were built in 1920, Milford didn't have any subdivision regulations until 1929, and they didn't have any zoning regulations until 1936. Back then, when in 1929, when the first, or 1930, when the first zoning map was filed, this section of street, or all the lots on East Broadway were in the business district, where two different, it had multiple family dwellings. There was all sorts of things that were allowed at the time. So this is obviously a pre-existing non-conforming structures and situation. I also searched the zoning regulations for any reference to single-family dwellings and whether there was any prohibition specifically or anything that addressed a situation where we have two single-family dwellings on the same lot. There's reference to it, but so they acknowledge the zoning regulations acknowledge that situation exists here in Milford, but there's no further discussion on that with that respect. Now, obviously, someone can't build two single-family houses on a single-family lot today, but back then you could, and maybe at some point in time, this is hypothetical, but maybe at some point in time, when the lot was originally created until the time of the subdivision or zoning regulations were put in place. Maybe those houses were owned by two separate owners. I went back to the tax assessor's office today and tried to get the earlier tax cards. The tax cards from the 60s and 70s for these two specific properties could not be located. It skipped from 4 Silver Street to 8 Silver Street, and then 798 East Broadway to 802 East Broadway. So I wasn't able to get that additional information. The reason I put these regulations in here, and Joe Griffith, I think, highlighted the main one, which is my first regulation I put in there, 4.1.4.3, specifically says that the height can be increased regardless of what section 6.3 says if you're in a flood hazard and flood damage prevention area. This is in special flood hazard area zone AE, and it's on the map. I don't know if it's AE 11 or AE 13, but it's in one of those zones. So it says specifically right here that the height can be increased. I don't want to bore you really any further. I'm trying to keep this as short as possible with making the points. The cases that were cited by Attorney Lynch, yes, they say something important. Varello says something important about variances. This is not a variance application. This is a decision by the Chief Zoning Enforcement Officer to issue a permit. So Varello does not apply. Town of Brantford versus Monroe is about the Brantford zoning regulations and how you interpret that zoning regulation. And that's why I attached at the back of this the Brantford zoning regulations that were in effect at the time. They're a different section number, but I made sure that these are the exact same zoning regulations that were in effect at the time of that hearing. So I highlighted the first part where it says no nonconforming use. It's 8-1C enlargement. No nonconforming use of land shall be enlarged, extended, or altered, and no structure or part thereof devoted to a nonconforming use shall be enlarged, extended, reconstructed, or structurally altered, except where the result of such change is to reduce or eliminate the nonconformity. Now, if you look at all the Milford zoning regulations that I've attached, there's several different provisions, one of which was as important as the 6.2.1, except in case of single-family homes. We have 2 single-family homes on this lot or lots. There's no, I don't want to get into whether it's 2 separate lots or not at this point in time, but whether there's two single-family homes on it, right? It says except in case of 2 single-family homes. The Brantford regulation does not say that. The Brantford regulation also does not say what 4.1.4.3 says, which is that the height can be increased if you're in a special flood hazard zone. This regulation was just changed in 2013. If it wanted to say elevated, it would say elevated. It says height increased. Also, I attached the zoning table because what's asked, or what the permit was issued for, this is an R5 zone, the building height stories is 3 feet, the feet in height is 35 feet. He's not increasing that. That permit's not increasing the number of stories. It's not going beyond that. It's not going beyond 35 feet. The other regulations talk about what the zoning enforcement officer's authorizations are and responsibilities are, all to the point that Mr. Griffith has that authority to do so. So I believe that is everything. So that's our position, and we ask that you deny the appeal. Thank you.
Thank you. Anyone else speaking on this appeal? Mr. Lynch.
Thank you. Let me state right at the outset, there was no intent in the filing of this application to question Joe Griffith's authority to issue the zoning permit. So let me just put that right on the table. That was never an issue, and the only issue was whether or not a permit can be given over the counter without a variance to the improvement to this property that was called for. And you can talk about the Brantford zoning regulations, but what I want you to focus in on is the language in the Monroe case, which talked about the effect of imposing the regulations on a situation at hand. Because we can talk about history, we can talk about prior applications. Mr. Griffith referred to 10 Silver Street. That happens to be my client's property. Yeah, he did improvements to that property with a variance. Okay? He didn't get an over-the-counter permit, he had to get a variance. And he applied for a variance, and the variance was denied. And I can stand here and again repeat what happened with the property at 41 Melba Street. Again, same situation as this. There were two single-family structures on one lot in a single-family zone. So clearly, what's at play here is not only a non-conforming use, it's a non-conforming structure. And you've had a week, or actually 4 weeks, to look at the packet that I gave you last month. You don't have to be a genius to read that case. And I read it right into the record, and the judge was clear, stating that a enlargement of a non-conforming structure upward, okay, doesn't talk about expanding the footprint, but an upward expansion of a non-conforming structure needs to have a variance. And our regulations call for that. I mean, Joe talked about how there is reference in our regulations to non-conforming structures and non-conforming uses. But it's clear in the regulation that if you want to expand either of those two things, you need to come in and apply for a variance. And you folks have sat here month after month with people that have come in with situations just as this, with one house on a lot, not two, but one house where they've wanted to expand and they've needed to get variances. And again, 41 Melba Street, you denied the application. I was before you, I think, 2 times. We were trying to scale down the house, and you were adamant that expanding that shorefront lot house was an expansion of a non-conforming use, and you turned the variance down. In this case, Mr. Plaxton received a permit over the counter without even coming before you. So I say, again, I stand by the comments that I made in my presentation to you last month. Again, with all due respect to Mr. Griffith, I think that what was done here was not done right, and I'd ask that you overturn the decision that he made to issue that permit. And I stand by the comments that I also made at the outset and reiterate those comments as to whether or not we have jurisdiction to come before you or standing to come before you with this application, because clearly under the case that I handed to you tonight, with all due respect to Kevin Crusaden, he's a very good lawyer. He works hard for his clients. But the fact remains, if this board in 2008 did something that flies in the face of a Supreme Court case, well, so be it. We're here tonight on this application, not on something that this board did or a prior board did in 2008. We're presenting this application to you, and I say that based on the standard of that case that I've submitted, that clearly we have aggrievement and we have standing to bring this application to you. Thank you.
I have a comment to make for you also. We talked about 10 Silver Street.
Yes.
Did he, when he presented whatever his changes might have been, he went outside the footprint, so he did need variances, I would believe.
Correct.
It was not just a straight-up addition, you know, so.
Mr. Siebel, I'd like to bring him to the microphone.
That's number
He
one.
can answer your question. I
Okay,
wasn't involved.
okay, hold.
If we're talking about the, let's go right to the 2013, I believe.
We need your name, sir.
Oh, I'm sorry. For the
Your
record, my
address.
name is, William Skip Zebel, 10 Silver Street. If, listening to Mr. Griffith's presentation to you, he mentioned 2 things on my property. And we naturally put on the second floor. We went for a variance and got it, and put on a second floor in the house. We had children. We needed the extra room. Then there was an issue on closing in a porch, which we settled with the city, and we signed a release with the city and cut the upper deck back because the lower one was grandfathered.
But that was also a variance because you were going outside the footprint.
That's correct, and that was denied. Yeah, so we cut it back. In 2012 to 13, we had already got hit by Hurricane Sandy, and we were naturally, we had to raise the house. It was mandatory for insurance and everything else. And not only that, to get a building permit. We got the permits, and we discussed it to add a bathroom in the front of the house. Now, my house, the setback everything's non-conforming. The house footprint is like 9'6", and you need 10 feet. So I went to see Steve in the zoning department, and he informed me that any new construction on that second floor, which we had put in legally, any new construction would have to meet the setbacks because it's new construction on non-conforming property. And I said, well, what do I have to do? He said, you're going to have to cut back. The second floor can't match the downstairs. I didn't move any encroachment. He said, you have to cut it back 2 inches. And I said to him,
So
2 inches?
that alleviated
Yeah.
a variance.
Yeah, it would give me, yes, it would. And I said, okay, what's my alternative? He said, a variance. And I respect what he said, and I talked over my wife, and I said, if I want a variance, I have to hire a very good lawyer like Tom, come here, maybe we'll cut it back 2 inches and put on a hip roof so that it hides, that the second floor is actually 2 inches back further. And that's what the story is in that. We didn't encroach on anything. We wanted to meet the footprint, but because it's new construction, we had to have the setbacks. That's what I was told by Steve. He knows his job. And I said, okay, that's what we're going to do. We cut it back. And I'm not here to stop the neighbor from raising his house. Lord forbid, 3.5 years, we're still not in our house. I just want justice here. I had to go for a variance to do that work, and I decided not to. And I think in all fairness, this application, if you read it, dormers and a balcony should have a variance. It should be going for a variance, just to be fair to everybody else.
Okay, thank you for your comments. And the other one, Mr. Lynch, you cited Melba. I think we needed variances on that particular one. It wasn't just a straight-up addition
yeah.
on the rear house. Yeah, okay.
Oh, yeah.
So, thank you. Any other questions for Mr. Lynch? Mr. Soto, did you have a question?
Mr. Griffith said that single-family dwellings are exempt from non-conforming.
I don't see the word exempt there. I see the word accept.
Accept.
And I read that regulation as saying if you have a single-family house on the Post Road in Devon and you want to convert that to a commercial use, you can't do it. That's the way I read that regulation.
So that's your opinion of that?
That's my
Okay.
opinion.
Thank you. Any other questions? Mr. Griffith?
Or at least get corrected. When I was making reference to 10 Silver Street, I was looking at the application from 2013, which shows a site plan in which, yes, they made sure that they noted from the street setback that the existing first floor was 9.6 feet and that the second floor was going to be 10 foot 0 feet. However, on the west side of the house, the existing setback is 3.9 feet and was going to remain at 3.9 feet. And the new addition was going to continue in that line. So the new addition, even though it was stepping back on the street face, was still encroaching in the required setback on the side yard to the west and was not required to get a variance.
Okay, thank you for clarifying that. Any questions, Mr. Soto? Go ahead.
Mr. Griffith, I have a question for you. First of all, I just want to thank you for all the improvements you've done to the building department. I worked with them for almost 29 years, and it's almost back to the way it was, so thanks for all that work you're doing.
Thank you, sir.
But anyway, on your zoning permit you issued here, it says elevate existing house in place, add second floor, access via pull-down stairs. Could you elaborate on the pull-down stairs and why not a staircase?
That's a description that zoning had insisted on putting in as part of their regulations. We have since eliminated the definition of story. What they were trying to make sure of is there is a distinction between a third story versus an attic space, and so our zoning regulations were talking about specifically requiring attics to be accessed by the typical pull-down stair, so that it could not be used as a habitable space. More recently, we have realized that that's probably making impositions on our citizens that we shouldn't be, and we've eliminated. There are other ways of regulating the building height in terms of number of stories, and so we've eliminated that provision in our regulations.
Okay, so was this permit issued for storage for the second floor? Or for a livable second floor? Because it's got the balcony and the doghouse dormers and stuff.
Well, specifically, if they came in and amended their permit to show a stair going up to that attic level, whatever you call it, habitable attic level, third story, they would be issued a permit to amend that application.
So they would amend it down the road.
They could amend it to have a stair, yes.
Any other questions? You have a comment, Mr. Crusaden?
Kevin Crusaden, I don't know if it's a clarification for Mr. Soda or not, but it's a pull-down stair because it's a loft storage area that could also be used for living space, but because of the size of the house, you'd not want a permanent stair, at least at this point in time, so I didn't know if that was clarifying what you're looking for.
Okay, Board, any other comments? Mr. Harris?
Mr. Chairman, if members of the public have all had their say, just as a reminder that the applicant always gets the last word.
Okay. You're all set, Mr. Lynch, okay? Is the board all set before I close this hearing? Okay. This hearing's closed. Okay, gentlemen, lady, your thoughts?
Well, my thoughts on this is, if you remember last year, about a year ago, we had, at the corner of Oakland and 195 Welch's Point Road, we had the exact same situation. We determined it was, this dwelling is 20 by 20. I feel this was an old garage that somebody over the years turned into living space, because it's exactly 20 by 20. We had the same thing on Welch's Point Road where it was 20 by 20. They wanted to put a second floor on it, and we turned him down. He ended up just reframing the roof to a gable and left it the same size.
They left it the same size without a variance. They increased, they went up a floor.
We turned him down on the variance.
Okay.
But he did come to this board for a variance
I
to
recall.
raise it exactly the same spot up in place.
I recall that.
You recall that?
Yep. Mr.
I
Haberman?
guess for me, this all boils down to whether we agree with Mr. Griffin's interpretation of 621 and 632. And I think, and I have no reason to dispute his interpretation of it. I guess if the court decision of Monroe versus was a Branford decision, if that could be shown to be applicable to our regulations, then maybe I would question the interpretation. But I don't think there's been enough presented here to show that there is an application to our regulations. So I have no reason to doubt his interpretation at this time.
Thank you. Anything else? We prepared for a motion on this, gentleman, lady?
Make a motion to deny the appeal and uphold the decision of the zoning enforcement officer.
We need a second. Do we have a second on upholding the decision of the zoning officer? We do not. Okay. We need another motion.
How about, before we make a motion, if we could have a little more discussion? I'm just getting hung up on 40...
Ken, go ahead.
Thank you. I'm getting hung up on 41 Melba, because that was a similar situation where there were two houses that were there, and they wanted to do an improvement. I think the improvement, as the chairman was mentioning, was going outside of the setback. But that was two houses on a lot that was zoned for one. There was a component of that for non-conforming use as well. Do you believe that the only reason why that they came before that board for the variance was because they were going outside of the setback? That was the main reason why? Can you help me recall that?
That's.
It was.
Yeah,
It
I'm
was.
sorry.
Well, we
I
also
can't-
we don't have a site plan here, so we don't even know if that balcony is within the setback or not. That balcony could be expanding that second floor.
I don't know if that's our decision, and that's what this hearing's about. It's about the interpretation of those regulations, those zoning regulations, whether or not we agree with Mr. Griffith or not. I can't recall a time that a variance has request for a variance came to our board when all they're asking for is a vertical, an increase, another floor being put on the same footprint, even though the footprint is encroaching on the setback. I don't know if we've ever denied that.
I don't think we've ever denied it either. Matter of fact, I think we forced them to do it.
That's right. Our issue has always been that they've been going outside of that
Well,
footprint. instead of more.
195 Welsh's Point Road, last year. Exactly, he wanted to put a second floor on it. It was 20 by 20 building, and we turned him down.
So you're deciding right now whether or not you need a variance? You don't have a
Well,
site plan?
if that
you don't have a s-
if that one came to us for a variance, I feel this one should come before us for a variance. I mean, we're taking away the people's voice by not giving them a variance. And now the neighbors can't speak against it or for it, so we're, by just issuing the permit, you're taking away the whole process here.
Okay. You want to make a motion?
I make a motion to overturn the Director of Land Use decision.
Second.
Reasons why? Again, please state them, Mr. Soto. State your reason why.
The reason why is I feel this needs a variance.
We have a motion to overturn the decision, and we have a second on the motion. Ms. Ferrante,
With the motion.
Mr. Habman,
Against the motion.
Mr. Soto,
With the motion.
Mr. Vecino.
I'm against the motion.
I'm with the motion, but we don't have enough to pass. Okay, so what do we do at this point?
The board has voted.
3-2. Okay. We're going to take a technical break. for a few
Mr.
minutes
Chairman,
here.
Mr. Chairman, just for the record and for everybody here, the motion failed by a vote of 3-2.
What do we have to do to move forward with this now? What else do we have to do?
No, this has been
It's
settled.
failed. Okay, thank you. We're going to take a technical break, recess for 5 minutes. Okay, we're ready to resume.
What's that?
Okay, we're going to resume this meeting. This meeting will come to order. Item number 2. Mr.
Item number
Hadman.
2, 0 Tanglewood Circle, Zone RA, cluster to R18, Thomas Lynch Esquire for April Culver, Trustee, Section 3-1-4-1, front yard setback to 20 feet where 40 feet required to construct single-family residence, map 122, block 904, parcel 5N.
Good evening, Mr. Chairman, members of the board. Again, for the record, my name is Thomas Lynch. I'm an attorney with the law firm of Lynch, Trimbicki, and Boynton. My office is located here in Milford at 63 Cherry Street. And I'm back before you tonight representing my client, April Culver. April is the trustee of her family revocable
Mr. Lynch, can you just pick up your microphone just a little? Thank you.
Got it? Mrs. Culver is the trustee of her family revocable trust, and we're before you tonight with an application to vary Section 3141 of the zoning regulations to allow for a 20-foot front yard setback for the property known as lot number 28 on Tanglewood Circle from the Rustic Acres subdivision from 1980. And as we know, in that zone, it's actually an RA zone that was approved as a cluster subdivision in 1980, and under the cluster regulations in effect, the setbacks are utilized in conformity with actually the R18 standards. So again, just some of this is repetitive from our last appearance before you, but I need to have a record established, so bear with me as I revisit history here. But as you know, we came before you back in the fall of 2014. This particular lot, lot number 28 on the Rustic Acres subdivision map, is a legal building lot. It was approved by the Planning and Zoning Board in 1980. There was, as you recall, a lot line adjustment between this and the other lot next to it, lot number 29, which my client also owns. And basically, she's had these properties for 30 years. She's been paying taxes on these properties for 30 years, and she now wants to develop these properties. And we came before you in the fall of 2014 with an application to vary Section 3141 to allow a 20-foot setback. This application is similar, but it's different from that application, which you ultimately denied without prejudice, and then in the spring, actually March of 2015, we came back to you with revised plans, and you approved for both this lot and the adjacent lot, number 29, a 30-foot setback. And if you recall, I made arguments at those hearings as to the existence of wetlands on both of these lots in the central and rear, or actually the westerly area of both of the lots. And the footprint of the house that was submitted on the map, originally submitted, and I know that Bill has a copy of it, and I asked to have it sort of passed along as we're making reference to it. But that map showed the footprint of a house that was 35 feet by 50. All right, and there was a substantial amount of the driveway impervious adjacent to the Lightixon property was shown on that map. And the map that we're submitting to you tonight actually shows a 25 by 50 foot house. So there's one change that's been made, and that is the footprint of the house that was submitted to our wetlands application, which I'm going to be talking a lot about in just a couple of minutes. But that's one change that has been made to the plan that was submitted to you in the fall of 2014, and then we ultimately got the approval in 2015 with the 30-foot front yard setback. But the other thing that was part of our presentation to you tonight, that night, which is different tonight, was I spoke about a hardship. And I said that the hardship was the existence of the wetlands on the property. And the argument could have been made, if you wanted to be cynical, that that was a speculative hardship, because there was another agency that we needed to go to get approval to build a house on that lot, and that was the Inland Wetlands Agency. So the argument could easily been made, well, that's great, it's a hardship, it's wetlands, but go to the Wetlands Agency, put together a well-engineered plan where you're going to fill in part of the wetlands, but then you're going to mitigate that by creating other areas of the property as wetlands, and hopefully you'll get your approval. Well, what happened after we were finished with this board in March of 2015, we did put together a very well-engineered plan that was submitted to the Inland Wetlands Agency, and the agency considered our applications between the fall of 2015, and then ultimately after some 6 public hearings, I have handed you a handout which includes the denial letter for a permit to build on this lot. The board, and I'm going to get into it in a second by making reference to the minutes of their April 6th meeting, the board went into great detail talking about the fact that on this lot, a portion of the lot was going to have wetlands filled for the actual construction of the house. We created a mitigation area, we created alternate areas where wetlands would be created. We my client spent an enormous amount of time and effort with Codispoti and Associates to come through with an engineered plan that we felt created a feasible and prudent alternative, which is what the Connecticut statutes talk about when you're bringing an application to a wetlands agency. The long and the short of it is, after all of these public hearings, we felt that we had submitted a good plan. We had an original plan that had been submitted in the fall of 2015, and Bob Weway amended that plan and brought it back to the Inland Wetlands Agency. A third-party review, if you know how wetlands applications get considered, under the ordinance, the city has an outside concern, a third-party engineering firm review the plans. The third-party review came back, and they raised some concerns about the way that the plans were laid out, but in summary, they recognized that this was a well-engineered plan and had no objection to the approval. So, long and the story short, and I've attached to our handout for you to look at its meeting on April 6th, the Wetlands Agency issued a denial for lot number 28. And again, reading for the record, the agency stated specifically that the applicant may investigate the following types of alternatives. Alternative number 3 is there are feasible and prudent alternatives with less wetland impacts the applicant can consider. Reducing the size of the footprint or moving the footprint on the site. That's what we're submitting to you tonight. Increasing the distance between the wetland and the edge of construction and disturbance. That's what we're submitting to you tonight. I've also attached the actual minutes from that meeting, and if you go to pages 2, actually just page 2, I've highlighted the comments from Dan Shopik, Kathy Collins, the commission chairwoman, Lily Flanagan, the other members, and each and every one of them spoke about how they were grappling with considering the application for this particular lot, lot number 28. They found no problem with lot number 29 because the actual construction of the house was going to be outside the wetlands area. It wouldn't involve any fill of the wetlands for the house on lot number 29. But as for lot number 28, it did involve a small area where there would be fill to allow for the construction of the house itself. So they denied the application. That creates a textbook hardship. And I have to be honest with you, I've been doing this for 36 years. I've submitted probably hundreds of applications to this board. And all of you sit here on the second Tuesday of every month, and you listen to applications, and you listen to people come in with reasonable things that they want to do to their property. And you know full well that 90% of the time when you grant a variance, if it's challenged in court, it's not going to stand up in court. You know that. This is not the case. This is something out of a law school textbook. If you have a piece of property with wetlands or rock ledge, okay, a legal hardship has been determined time and time again by case law. It's defined in statute as something that's germane to the land itself. It can't be an economic hardship. Okay? It can't be a self-created hardship. This is a legal hardship right out of the textbooks. And when I stood before you arguing this the last time, yeah, I was saying it was a hardship, but again, in the back of your minds, you could very well have been thinking, well, hey, listen, take it to the Wetlands Agency and let them approve it. Well, we did, and they didn't. And the plan that's submitted to you tonight, the map that you have, shows a reasonably sized house. It will be constructed out of the wetlands. There will be no fill for the construction of this house. And I know there's neighbors here, and you know, for the last year, all I heard before the Wetlands Agency was, don't destroy the wetlands, don't kill the box turtles, respect the property. Well, this addresses that. And the flip side of the coin is, this is a legal building lot that my client pays taxes on, and she's entitled to develop it. She's entitled to develop it within the confines of the law. And one of the greatest comments that I heard during our prior presentations from one of the neighbors was, play by the rules. You got to play by the rules. That's exactly what we're doing, is playing by the rules. If my client didn't play by the rules, she would have just gone out and built a house in the wetlands and said, to heck with you. What she's done is she's come before this board to get a variance for 30 feet to attempt to get a permit to build. We went to the Wetlands Agency, and they said, no, we're not going to give you a permit because you're going to be filling wetlands for the construction of the house. We're now back to you with an actual legal hardship, a denial letter from that board that says you can't build, move the house, shift the footprint. Their comments in the minutes are replete with, hey, I don't have a problem with lot 29, I got a problem with lot 28 because it involves fill for the construction of the house. And I dare say that if this application is granted by you and we go back to the Wetlands Agency, they will approve it. The last thing that I attached to my handout to you is a copy of the vision appraisal assessment records for this lot. And the city of Milford has this property appraised at $116,380. She's been paying taxes on this lot for the last 30 years to the tune of $116,380. And I submit to you, my last argument is that if this application is not granted, it creates a legal confiscation of my client's property. And there's case law replete that property owners, if they have a legal building lot, it's been approved by the Planning and Zoning Board, they have the right to develop the lot as long as they come in with an application that meets reasonable standards. That's what this does. So on behalf of my client, I'm asking you to do the right thing, grant this application, and if there's any questions, I can answer them best I can. Bob Weway could not be here tonight. I don't think it comes under your purview to be talking about engineering questions. I mean, he's spent, like myself, 1.5 years working on this project. He has a computer filled with plans and drawings and drainage and everything else, so that he would be best served to answer, but that's not under your purview. We're here asking for a front yard variance. And the last point, Bill Soto, the last time we were here, picked up on it even before I got to it. If you look to the map, the deed line of this property is some 10 feet back from the improved roadway of Tanglewood Circle. So you look at that map, we're not really looking for constructing a house 20 feet. It's really 30 feet. It's 30 feet off the road. And the regulation calls for 40. So I think with all of that combined, this is a reasonable request, and there's a clear legal hardship that exists here, germane with the land, and we'd ask that you approve the application. Thank you.
Any questions for Mr. Lynch? You wanted to see that map that was passed on?
Yeah, if you look
And
at
any
the old
questions?
map, if you look at the old map too, the driveway has been moved. The old driveway was closer to the Leidickson's property. It's now moved flush front to the house to go right in. I suspect the best layout would be a 50-foot raised ranch. The wrap wall, the wrap wall has been moved. It is actually 48. The other one was 50. Yep.
Mr. Vecino, go ahead.
Attorney Lynch, from, just to verify and validate the hardship a little bit further, wetlands presence on other lots within this neighborhood, is these two lots, and specifically this one, I know we're talking about 29 as a reference point as well. Right. Are those the only two that have wetlands within those?
I have no idea, John.
Okay.
There's houses built on all the other lots. My
Right.
client happens to have the two lots that have wetlands on it.
Okay.
And she needs to come before you and the Wetlands Agency to build a house. Clearly, the other houses were built, and let me buttress that because the subdivision went through in 1980. We did not create an inland wetlands agency until the 90s, so we operated under the DEP regulations, the predecessor regulations of the DEP, so that I honestly don't know what went on with the construction of the other houses.
All right, thank you.
Right?
Any other questions for Mr. Lynch? Anyone else speaking in favor of this application? Did you have a question? No, you didn't. Is there anyone here opposed to this application?
Gary Davis, 137 Tanglewood Circle. In an effort to move things along quickly, because we've been through this twice before with you, the neighbors and I got together, and this page just summarizes 6 bullet points of things we've discussed before. In italics, I've listed the statutes that are pertinent here. I don't want to spend a lot of time on this, but just quickly go through these previous issues that we discussed. As mentioned before, the ZBA already denied a 20-foot setback on these properties. Over 20 neighbors got up and spoke the first time before you spoke in opposition to this. I want to remind you the applicant has no intention to construct a house. There are no house plans, unfortunately. There's only the footprint. The applicant, a real estate agent at the time she purchased the property, was aware of wetlands on the property at the time of the purchase, and therefore she has created an unnecessary hardship. How can you expect someone to buy wetlands and then come to you and say, oh, I have a problem, I have wetlands, I have a hardship? The applicant, therefore, is only seeking financial gain upon selling the property. You should not consider the amount of money that she has spent paying taxes on this property. That is not relevant. That's a financial issue. The proposed house with a 20-foot setback would not conform to others in the neighborhood. It's much smaller, and it would also be much closer to the street than the 50 to 100 feet or more of all the other houses in this subdivision, thereby decreasing property values. Milford zoning regulations say that you should not approve something as injurious to the neighborhood. I also want to let you know that the applicant misinformed the ZBA. Might have been you, Mr. Vecino, who had asked if the footprint was binding. And you were told yes, that it was. And in fact, as Mr. Lynch mentioned, The Inland Wetlands has approved Lot 29 with a footprint presented to them of only 1,196, whereas what was presented to you and that you approved with a 30-foot setback was a footprint of 2,048 feet. They cut the size down almost half. So if you're considering not just the 30-foot setback, but the impact on the neighborhood and how this is conforming, I think you've been vastly misled. Talking with Mr. Harris about this, I understand that this is okay as long as they maintain the 30-foot setback. They can actually build a house that's smaller. So it's unfortunate we don't have house plans, something really for you to consider, not just the 30-foot setback, but what is the impact on the neighborhood. On the back of this is new information to present to you. You were just asked about wetlands and other properties. I live right next to next to Lot 29, the lot that was approved. There's a swale that runs behind all the properties on that side of that street, filled with water. I'm sure if it were tested that wetlands would run down the hill from these properties all the way to a brook, and it would be considered wetlands. The first bullet here is, again, as Mr. Lynch had said, the Inland Wetlands approved Lot 29 with a 30-foot setback. The next bullet is the minutes. Mr. Lynch has already gone over that. I won't belabor it. But I think it's important. They're talking about moving the house or reducing its footprint. I guess there are various interpretations to that. Mr. Lynch interprets this as moving it closer to the street. Maybe it should be moved closer to the side. Maybe we should be looking at a side variance instead of a front variance. They also mentioned reducing the width of the rear yard. That is something that could be done and still maintain the 30-foot distance from the street. The next bullet is from the Inland Wetlands minutes from a previous meeting, where in their denial they suggested proposing fewer lots. And what they're talking about there, as Mr. Lynch has said, Lot 28 and 29 are both approved legal building lots. The Inland Wetlands was very clear that even though these are two lots, they exist on one wetland. And it was their recommendation that the two lots be combined and that a single house be built. I think that's still an option that is feasible and that is financially prudent for the applicant and something that she should consider. Also, there is a lawsuit with the denial of Lot 29 by the Inland Wetlands. If Mr. Lynch should prevail in that, then he would get by with a 30-foot setback. There's no need for a variance for the 20-foot setback. The current proposal shows a house of 1,200 square feet. That's uncharacteristic of the homes in the neighborhood. In fact, we have deed restrictions in our subdivision that have required a minimum of 1,500 square feet of living space on the main floor for a raised ranch, which is what we presume would be constructed here. And finally, the ZBA approval must meet the minimum variance necessary for reasonable use. At the very bottom in bold, I've highlighted the Milford zoning regulations that the variance is granted by the Zoning Board of Appeals is the minimum variance that will accomplish this purpose. That is the purpose of providing reasonable use. Now, how do you determine what the minimum variance is? Does he need another 10 feet? Does he need another 5 feet? It's an inland wetland decision, and unfortunately, no one here is qualified to determine how much this house has to move in order to satisfy inland wetlands. And Mr. Lynch has suggested what they might do, but I don't think you can be assured of that. Perhaps by cutting back the size of the backyard a little bit, as they had recommended, maybe only a 5-foot variance is what is needed. I think it puts you in a tough spot of how are you supposed to determine what the minimum variance is that's required in order to satisfy inland wetlands. And I would suggest to you that it's not this 10 feet, and it's possibly less. So in summary, let me simplify the issue before you with an example. Imagine that I purchase a legal building lot knowing that it contains substantial wetlands. Now I want to sell that lot at a profit, so I need to prove to a developer that a house can be constructed with inland wetland approval. To accomplish that, I propose building a house that is much smaller than the others in the neighborhood and ask the ZBA to approve a variance allowing the house to be placed uncharacteristically close to the street. Should the ZBA grant such a request, so that I could damage the character of the neighborhood, decrease surrounding property values, gain financially from an ill-advised purchase that created an unnecessary hardship? I don't think so. Please deny this application. I do have one procedural question for Mr. Haberman. I know that you had recused yourself from all of the previous discussions on this property. Just for the record, I would appreciate if you could explain why you're participating tonight.
I probably shouldn't have. I knew somebody in the neighborhood, but the reality is, so I thought I should recuse myself, but after speaking to the officials, I didn't have any monetary or any other kind of connection to these people. So, and I pretty much know, I've lived there all my life, so I probably know most people in a lot of different neighborhoods, so I probably shouldn't have recused myself in the first place.
Okay, thank you. I appreciate that.
Anyone else speaking? Please do not be kind of repetitious over anything that he might have
I
covered.
will try
okay?
not to be repetitious.
And we're going to kind of limit the time to about 3 minutes, please.
Right. My name is Diana Nitko. I live at 236 Tanglewood Circle. This board approved spot zoning in March of 2015, a change from RA cluster 30 to R18 with a 40-foot setback. This property and the adjacent property, in spite of the fact that it was arbitrary to guidelines set forth in ZBA Rule 9.2.2.3, the granting of that variance will be in harmony with the purposes and intent of regulations and will not be injurious to the neighborhood or detrimental to the public welfare. Until this change, the smallest site in this neighborhood was 30,000 square feet. Now, Attorney Lynch comes before your board requesting another variance for a change in the setback from 40 feet to 20 feet. There are 95 houses in Rustic Acres. All were built according to zoning regulations. Not one of them required any variances. Not one of these houses has a setback less than 40 feet, with most 50 feet and over. My house has a 55-foot setback, not including the 10 feet from the curb that the city owns. Regulation 7.1.3.1, proposed use shall be of such location, size, and character that in general it will be in harmony with the area and will not be detrimental to adjacent properties in accordance with the zoning classifications of such properties. The adjacent properties are zoned R30. Attorney Lynch is using hardship again as a reason for this change. Webster's Law Dictionary defines unnecessary hardship as the deprivation of an owner's right to the beneficial use of the property, which he stated, that is caused when a zoning ordinance makes it impossible to receive a reasonable return from the property. This may justify the granting of a variance if the use permitted by the variance will not alter the essential character of the locality. Unnecessary hardship may involve unique characteristics of the property itself, not economic difficulties of the owner. This variance did alter the property and the neighborhood. This was a self-imposed hardship when Mrs. Culver, a real estate agent, at the time she and her husband purchased it, she knew full well that there were wetlands on the site, and she was well aware of the R30 zone. For these reasons, I ask you to please deny this application.
Can I just ask you a question, please? I just want to clarify something that you said.
Yes, sir.
You said that this board changed the spot zone. This board does not do that.
No, I said zoning, excuse me, the zoning board.
This is the Zoning Board of Appeals, so it was the Planning and Zoning Board. Okay. I just want to clarify that we did not
no
do
problem.
anything when it was zoning changed.
No problem.
Anyone else speaking?
Mary Ellen Magura, 144 Tanglewood Circle. I'm the teacher. I'm the one that talked about fair play that was referenced before. And I got to bring up again that what we're dealing with here tonight is just an unapologetic and unabashed display of ego from a woman who is refusing to even consider the word compromise. We all know the backstory here. We've heard it over and over in these meetings for the past nearly 2 years. This woman knowingly purchased land containing an abundance of wetlands and then demanded the right to destroy the wetlands that she knew full well were on the property at the time of purchase, and to overturn all the rules that 95 other homeowners have abided by to accommodate her desire to profit from her purchase. This question, this request for a 20-foot setback has been asked and answered. She asked, you said no. Nothing, absolutely nothing, has changed that could rationalize the no answer becoming a yes. In fact, what has occurred is reason for your no answer to remain a no. And what has occurred is this: tremendous compromise from the city of Milford and from the Rustic Acres neighborhood. Number one, your board has allowed for a 30-foot setback, thereby significantly changing the character of our neighborhood, where all the other homes are placed at a minimum of 50 feet from the street. But this was done in the spirit of compromise. Wetlands should not be compromised, should never be compromised, but they have been. The Inland Wetlands Committee has approved one of the 2 building lots, thereby significantly altering an area of wetlands precious to our neighborhood, our city, and indeed our very environment. This too has been done in the spirit of fairness and compromise. A further compromise has been offered by the Wetlands Commission repeatedly, which has cited so many times that combining these 2 parcels into one lot could significantly reduce the impact on the wetlands while allowing Mrs. Culver to build one good-size home on a beautiful large lot and realize a lovely large return on her investment. Another proposed compromise. But none of this was good enough for Mrs. Culver. Mrs. Culver demands a complete and total victory. The word compromise is not in Mrs. Culver's vocabulary. She will settle for nothing less than exactly what she demands. How could that possibly be fair? Why would you possibly grant this petition?
Can you just speak to the merits of this, not attack the person that,
Yep.
the applicant, if you don't mind?
Yep. As the decision now stands, there is compromise on both sides. We have lost some of our precious and vital wetlands, and approval has been given for a home to be built which is completely out of character for our neighborhood. And we, the residents of Rustic Acres, have gained nothing from this decision. Mrs. Culver, on the other hand, has realized tremendous gain. Though being granted permission for 1 house instead of 2, she's being allowed to destroy a significant amount of wetlands, and she's being allowed to build a house that will damage the character and the market value of our homes, all while making a significant profit. By granting this petition, you would be destroying any sort of compromise or fairness. You would be capriciously reversing your own previous decision. You'd be turning your back on 95 tax-paying families in the Rustic Acres community. We have done, the Rustic Acres neighbors have compromised enough. It's time for a little compromise from the other side as well.
Anyone else speaking? Please try and keep it to around 3 minutes because we're getting a little bit longer with each presentation. Thank you.
Good evening. My name is Mimi Mudrick. I live at 158 Tanglewood Circle. I've been a city resident for 26 years. And I moved to Tanglewood from Weppawag Drive 9 years ago for one main reason, because of the zoning regulations that were intact, and I did my homework. Now, the zoning regulations and specifically the setbacks were what were attractive to me. I want to retire there. This is why I wanted to move there and pay the higher tax. And we struggle, but it's worth it. It makes us work harder. My home is 90 feet from the property line. And I'm deeply concerned this project will have a significant negative impact on the neighborhood. And I'm deeply concerned this project will set a precedent. Please deny this application. Thank you.
Thank you. Anyone else? Come forward, sir, if you're ready. Please come forward.
I'll be quick. I'm Don Nitko. I live at also...
I'm not trying to deprive anyone of their time to speak, but, you know, go ahead, sir.
I understand. After the first go-around, it took much more time than you anticipated, I know. Okay, my name is Donald Nitko. I live at 236 Tanglewood Circle. I'd like to give you a historical notch in this neighborhood. About 25 years ago, a former mayor, Henry Povinelli, lived approximately 200 feet from the property in question tonight. He lived on Beverly Road. Hank, his wife had severe leg problems. She could barely go up and down stairs. So Hank decided, you know what, I want to split my property in half and put up a single level ranch-style house. And he created 2 lots. Well, it was soundly defeated. And the reason that was given at that time was that it would create 2 non-conforming lots which were not in accord with the character of the rest of the neighborhood. My. 25 years ago, a former mayor didn't have the clout to get that done, but a woman from Vero Beach, Florida, apparently has that amount of money that she can afford to dump into this. Just keep that in mind. By the way, whether you voted, I'm not sure your political affiliations, but Hank was an okay guy. I incidentally spoke against that. Okay. I'd like to also, we've been beating this into the ground, this hardship thing, but not for the property. I'd like to touch on the hardship aspect, not of this property, but all of the other properties in Rustic Acres neighborhood. When a family buys a house in certain areas, like Morningside, Woodmont, Great River, they expect a certain well-defined exclusivity in those neighborhoods. In Rustic Acres, we expect all properties to conform to cluster zoning housing, including the house size and the setbacks. This is what makes our area desirable. So, that being said, what Mrs. Culver is proposing, that her property should not have to qualify to those standards, but all the other 95 homes should. Therefore, this puts the label of hardship on all of us, all of the homeowners, especially the 5 of them that are both on both sides of it and the 3 across the street. They all happen to be here tonight. Those 5 families especially are going to suffer the most because of her hardship. No, it's not her hardship anymore. It's our hardship. Please, I'm begging you, do not approve this petition. Thank you for your time.
Good evening. I'm Joan Caginello. I live at 17 Westminster Court, and my house property borders the back of this 0 Tanglewood. And my home is set back from the road 100 feet from the street. I've been coming to the city meetings regarding this for, as we said, almost 2 years, and I'm not going to go, going to say what all my neighbors have said. But what I am going to say is that there has been some discussion in the past, over these past couple of years at some of these meetings, that the neighbors are unreasonable and that we would never be happy with anything, any kind of plan. We just want to have that left. And I just really want to clarify that and make this very crystal clear. My husband and I have lived in our home for over 30 years. During that time, we've seen tremendous growth in our neighborhood. We had been the only house on Westminster Court, which is a cul-de-sac our house was at the top of the hill. Since we've been there, other houses have been built on our street. We have witnessed the expansion of Upper Tanglewood. Tanglewood used to just end up by Mountain View Drive. We've seen the expansion of Beverly Road, the new homes on Mountain View, the creation of Yellow Brick Road and Honeysuckle Lane. In total, probably more than 20 houses have been built during our tenure in that neighborhood. We never, ever have contested any home that has been built, not one of them, not for any reason. So let me just say that to be really clear again. We've never come to a ZBA meeting, to a planning and zoning meeting, to an inland wetlands meeting to try to stop the development in our neighborhood. This is because all the other homes in the neighborhood followed the rules, and they conform to all the city requirements, which you are here to enforce. So you've been appointed to your positions to uphold these roles of the city. Please don't compromise for the good of the city. Please don't do that. By having this individual be allowed to ask for special permission. It will do no good for anyone except for the individual who wants to sell these lots, not live here in Milford like we all love to do. Please listen to your conscience, do what's right, and I'm going to respectfully ask you to please come to our neighborhood. We had a wonderful experience with the inland wetlands. You know, we kind of got a compromise. One lot was approved, one lot wasn't. But they took the time to come out and they walked that property not once, not twice, but several times. There were several times that we saw our streets lined with cars from people that were coming out to look and see what the character of our neighborhood is. So I respectfully ask you to please come. We would love to have you come to the neighborhood to see what you're really talking about, not just on paper.
Thank you. Anyone else speaking?
Good evening. Thank you guys again for hearing this matter. My name is George Komorowski, 173 Tanglewood Circle. We live directly adjacent to the lot in question, lot 28. And we just have great concerns over any building and construction so close to our property line. Any granting of this variance would be of substantial detriment to both properties on either side of the subject lot in question. In our hearings with the Wetlands Agency, they had an independent consultant's report requested, which indicated that very shallow bedrock exists. And any disturbance of these wetlands or development on lot 28 would certainly cause runoff and flooding on our property. Our pool is very close to the property line, and it has a concrete lining. The underground disturbance caused by any construction of such close proximity it could result in a catastrophic failure of our pool. This would cause severe financial hardship for my family. In addition, with the applicant's plans placing a septic system right on our property line, this raises many health concerns upon its failure, and it's unacceptable. We have 2 young children, one on the way, and their health and safety is of our utmost concern. Developing this lot would create hardships, not amend them. All properties in Rustic Acres community have a minimum 50-foot setback. Our home is set back more than 60 feet. The applicant is not attempting to achieve parity with the other homes in the neighborhood. Any possible hardship being presented by the applicant is self-inflicted. Any variance permitted in lieu of this would result in an exception being made, which is not characteristic of the neighborhood. Any construction of septic systems so close to property lines and wetlands while having such shallow bedrock would certainly be of substantial detriment to our property. And I would like to point out again that this request for variance was previously denied by this board. Variances are an exception, not a rule. This request for variance is not being asked for in good faith, as a more prudent and responsible solution was in fact requested by the Milford Inland Wetlands Agency and was blatantly ignored by the applicant. This being to construct one home, as was mentioned, not 2. The alternative would allow for the least effect on the wetlands, eliminate the need for a variance, allow for a reasonable return, and keep with the character of the neighborhood. We have 20 or more families involved in this fight, countless man-hours, time spent away from our family, from our children. We are here because we care greatly about our neighborhood. We have these zoning laws in effect to protect the integrity of all neighborhoods. What the applicant is requesting is wrong. We've been here before. How many times are we going to keep doing this? It's getting to the point where the only ones making any money are the attorneys, who I am sure will drag this out as long as they can, but we will be here to the end. Please deny this application again. Thank you.
Can I ask you a question?
Yes, sir.
I've heard the name of that area a couple of, what is the name?
Leidixon?
What is the name? Is it Rustic, what?
Rustic Acres?
Is it an association? Do you have bylaws? No. So you don't, because I've heard a lot of stipulations on the size of houses and what they have to be, but you don't have anything as an association?
No.
Okay.
There are deed restrictions, nothing, no.
Okay.
All right, thank you.
Good evening, my name is Mike Magura, 144. My name is Mike Magura, M-A-G-U-R-A. I live at 144 Tanglewood Circle, directly across the street from the properties in question. And I support the statements made by my neighbors in opposition to the proposed variance on 0 Tanglewood Circle, because it just changes the character of our neighborhood by allowing houses to be built only in a 20-foot setback. My house has a 90-foot setback, and we've been there for over 30 years, and we pay taxes as well.
Thanks, Paul. Karen Zaneski, Z-A-N-E-S-K-I. I'm at 150 Tanglewood Circle. I know we're all shot. We've been here several nights. It's getting late. I feel sorry for the people behind us, but please understand, we need your time and we need your attention. These are our homes. One of the things that Attorney Lynch cited was something about the city engineer. My dad was an engineer with the city, and he had said to me, and I've told you this before, but to reiterate, this is on rock, okay? You're digging a septic tank. There's going to be blasting. As a taxpayer, I'm concerned not just about my property right now, but what's going to happen when down the line there will be lawsuits if foundations crack, if pools crack, if lawns get flooded. This is going to change the whole runoff. This is a bad situation for our neighborhood and for the city of Milford. That Mrs. Culver was well aware. Actually, Mrs. Culver, from 1974 to 1986, has owned, that's a 12-year period, has owned 8 properties. She knows what she's doing with real estate as an agent and as a property owner, developer, I should say. This, again, is changing the entire character of our neighborhood. I'm 55 feet from the curb, my setback, and I'm one of the lower ones. If you talk to the city engineer, I think you'll find that he is recommending one house, a prudent alternative, one large house, combining these 2 lots. And I'm not going to repeat what neighbors have said. I would just like to respectfully request that you deny this application for our good and for the good of the city of Milford and all of our taxpayers. Thank you.
Good evening. My name's John Mudrick. I'm at 158 Tanglewood Circle. I'm across the street from the proposed houses as well. If you haven't been in our neighborhood, it's a very unique neighborhood in Milford. I've been in the city now for 26 years, and I love Milford. There's no doubt about it that way. And we decided we wanted to move. We found this neighborhood, and we were just really inspired with how nice it was, how well kept it was, the zoning rules, and just how everything was laid out there. And with a 40-foot setback minimum, everybody else abided by the minimum. And everybody basically went above the minimum. My house is 90 feet off the street. Now they're proposing they want to build a house 20 feet across the street from my house. I didn't buy my house as a financial investment. I bought my house as a home to live. I live there. I love it. I plan on staying there. And I just hope you vote to deny this. Thank you.
Anyone else speaking?
Good evening. My name is Darlene Frost Davis, and I live at 137 Tanglewood Circle. I support the statements made by my neighbors in opposition to the proposed variance on 0 Tanglewood Circle because it changes the character of our neighborhood by allowing houses to be built with only a 20-foot setback. My home is located 52 feet from the street, and also I live right next door to lots 29 and 28. So please deny this application. Thank you.
Thank you. Anyone else? Anyone else speaking in opposition?
Good evening. My name is Linda Wadowski. I live at 200 Tanglewood Circle. We moved to Rustic Acres 30 years ago because we found it just driving through and fell in love with it. My house is 90 feet back from the road, and I urge you to deny this application. Thank you.
Thank you.
My name is Steve Orlak. I live at 41 Old Country Lane. I have a 54-foot setback from the road, and I'm in agreement with my neighbors in opposition to this variance. Thank you.
Thank you. Anyone else speaking? Anyone else speaking in opposition? Mr. Lynch, you may rebut.
Thank you. Clearly, this is a lovely neighborhood, and that's why my client wants to build 2 lovely houses in this neighborhood. And I'm sure she would love to have a 40-foot setback or a 50-foot setback or a 60 or 70-foot setback. But the existence of the wetlands precludes that. And under our zoning regulations, under our state statutes, under cases, it allows her to come before you with a reasonable request and say that the existence of the wetlands creates a legal hardship that does not allow her to build a house 50 feet back or 40 feet back or 60 feet back from Tanglewood Circle. That's a point that can't be lost. And secondly, in terms of how a single-family house is going to impact the neighborhood, it's a single-family neighborhood. I'm not standing here proposing a multifamily development. I'm not standing here proposing a commercial development. I'm representing a client who wants to build a single-family house in a single-family neighborhood. So all of the comments about the impact that this house would have on the neighborhood, I'm sorry, I think that it's just disingenuous. She wants to build a single-family house just like all the other houses in the neighborhood. There was a comment about the size of the house and how it would relate to the deed restrictions that were recorded back in the 1980s in the Rustic Acres subdivision. I represented Lou D'Amato. I helped draft those regulations. And I can tell you the footprint calls for 50 by 25. It's going to be 1,200 square feet, a 2-level house. It's 2,400 square feet. So one of the neighbors making a comment about a 1,200 square foot house. Sorry, that's wrong. This is a 2-story house. The footprint calls for 2,400 square feet, 2,500 square feet. If there is a 2-car garage, rather than having the 2 off-street parking spaces in the driveway, that would be somewhat reducing that, but clearly it'll be in excess of the regulations that are called for under the deed restrictions, actually the declaration of restrictions for that. There was talk about the Inland Wetland Agency and wanting to have a combination of these 2 lots. That was never a consideration. It was made very clear right from the outset that my client has 2 legal building lots. She had 2 separate applications before the Wetlands Agency, and perhaps some of the neighbors had offered comments saying, well, why doesn't she combine the lots and build one house? She owns 2 legal building lots, and she presented 2 applications to the Wetlands Agency. They approved one, And I have given to you the comments that they made relative to the reasons why they denied the application presented for this lot. The application before you tonight addresses those concerns. So, I mean, we're between a rock and a hard place. When we first came before you, I was claiming a hardship, but it left the door open to have another agency still issue a permit. Again, I reiterate that we have gone to that agency. They've denied the application and have offered, in their denial letter, reasons for the denial and suggestions for a feasible and prudent alternative, and this application before you tonight addresses that. In terms of uniformity of setbacks along that stretch of Tanglewood Circle, you've already approved the other lot with a 30-foot setback. So you're going to have that lot built on, and the house on this one would be 20 feet, again with the other 10 feet. So I think that there's a reasonable setback that's set forth in this application. And again, stressing the point to you that the other houses in the neighborhood were built without seeking variance of the zoning regulations. That's because those lots didn't have wetlands. This lot does, and we're before you with this application seeking an accommodation so that the house can be built.
Lot number 28 at this presently has a 30-foot setback that was approved, correct?
That was approved with a larger house, a house that was some 10 feet
So the only thing
wider.
that's really at issue right now is the extra 10-foot.
Correct.
Okay. Go ahead, Mr. Soto.
Attorney Lynch, I just have one question for you. You got a 12 by 12 ground level patio behind the house?
Yep.
Okay, if you put that on the side of the house, could you push the house back anymore, another 5 feet maybe?
No, the way this is laid out, Bill, and one of the neighbors made a comment, why don't you move it to the side or whatever? Where it's located with the septic system, that, you know, you got to keep in mind the septic system that's been engineered and approved by the Milford Board of Health in June of 2014. But this is the only site on the lot that the house can be situated. I mean, Bob Wee spent a lot of time trying to, you know, do this, do that. The way that this is presented to you is really the only way that the house could be situated on the lot.
Any other questions? We're all set with our questions? No. Yeah, we're not going to have any other rebuttals. It's not a matter of time.
Now, Mr. Chairman, I would just like to remind the public that the applicant always has the last word. If the applicant waives his right for a last word, then of course he may do so.
Mr. Lynch, you would again have the last rebuttal, or
I have no
do you
further
feel
comment.
do you feel that you would want to hear anything else, or are you all set?
I think Mr. Harris stated it. I had the last word and I just had it.
Okay. Any other questions for Mr. Harris? I'm sorry, for Mr. Lynch? Any other questions? Okay, this hearing's closed. That question is the 10-foot that the wetlands is saying would best way to build the house. So, you know, the decision would be, we hear all the arguments against it, but again, how do you keep everything, you know, I can hear what they're saying. They want everything to be the same in their neighborhood, and it's not the same in everybody's neighborhood. So there is room sometime to have differences. Mr. Soda.
I mean, 30 years ago when she bought it, she did buy 2 approved building lots at the time. She didn't buy 1, she bought 2, and she just waited to develop them, and then inland wetlands came around.
We're not going to be yelling out, sir. We're not going to be yelling out.
I mean, everybody has the right to develop their property. I mean, I know, you know, it's a nice neighborhood and all that, but she did buy 2 approved building lots.
Any other comments? Ms. Ferranti, you look like you have something to say. No? No? Any other discussion? We need a motion. We don't have to make again, if we want to belabor this and put it off, we still have time on deciding if you want to think about it. We have 65 days. We can go 2 meetings. If you think you're ready this evening to make a decision on it?
I make a motion to approve.
I second.
I approve based on the survey that's presented before us today in the exact footprint, and the reason for my approval is the legal hardship within the lot, and they have a valid building permit, a legal lot to build on.
We have a motion to approve. We have a second on the motion. Ms. Ferranti.
With the motion.
Mr. Habman.
With motion.
Mr. Soda.
With the motion.
Mr. Vecino.
With the motion.
I'm with the motion. It's unanimous.
They don't have a legal building permit because the perk tests were done illegally. I hope it goes to the Board of Health again.
Okay, we're going to take a break before we have our next item on the agenda. Okay, we're going to resume this meeting. Mr. Haberman.
Item number
5.
Excuse me, 25 Field Court.
28.
I'm sorry, 28 Field Court, Zone R5, Nancy Rogers, owner, Sections 4-1-4, east deck projection to 1.6 feet, where 8 feet permitted to construct a deck on a house to be elevated in place. Map 28, Block 574, Parcel 4.
My name is Peter Crabtree. I live at 64 Stanley Street, New Haven, Connecticut, and I'm here on behalf of Mrs. Nancy Rogers. And if you may recall, last month this application was denied without prejudice. And what we were attempting to do was build a rear deck with access. And we had opposition from the neighbor on the right-hand side as viewed from the street. So, in keeping with the denial without prejudice, we eliminated that deck access on the right side, and tonight we're only asking that you grant the variance for the deck access on the left. again, at a larger scale, you can just see the deck that was under this consideration for tonight. This is just what it looks like from the rear. This is what it looks like from the side. And as I say, we eliminated the deck access on this side. We've given the neighbor here, who formerly objected, a 5-foot setback, which is required. As I pointed out last month, there have been some legacy variances granted here, 3 in 2013 and 1 in 2009. So it's not unusual to have a deck on the house facing the water and having access to come around from a side door. And as I pointed out last month, there are hurricane windows there and facing the ocean, so there won't be any issues of splashback, eliminates any door. And of course, having a door on the side of the house, if we're going to reach the deck, we do need access. And when I say reach the deck, the rear deck. I know it's been a long night tonight. I don't want to be repetitive. I still have the handouts from last month, have the pictures of the various homes in the neighborhood, and these are just from last month's file, and I'll just resubmit them if anybody cares to look at the pictures again. I'd be glad, I want to keep it brief because we were here last month, but if you have any questions, I'll be glad to answer them.
Yeah, I think things are pretty fresh in our mind as to what happened last month. Mr. Soto, did you have a question?
Yeah, Mr. Crabtree, I thought we were going to do something on the left side, move those stairs to the house and cut back on the deck coming out 5 feet and just make like a walkway to the back deck. I thought we addressed that we'd like to see that done too.
This, of course, we're entitled to put the stairs up and put the landing up. That's allowed under zoning regulation.
I know that, but you see how the right side, you put the stairs tight to the house?
This is the left side of the house here.
No, but the right side, you see how you move the stairs tight to the house?
This side over here?
Yeah, this side over on the left side, you have like a 1 foot gap there, and then the deck is sticking out 5 feet, the walkway. You got a pen on it? See right here? Your stairs are tight to the house.
Okay.
Last month, we'd mentioned this side, we'd like to see them tight to the house and cut this part of the deck off, all the way down. So it was just a walkway. Instead of being 5 feet, that would cut back on your setback.
This shouldn't be shown because it's an optional if in case the variance was denied. That's why I'm only showing the half of that drawing here. This is the application that's under consideration.
Yeah, but it's still 5 feet. See this here?
Yes, it's 5 feet.
It doesn't need to be 5 feet. Code is 3 feet.
If, in your opinion, you aren't comfortable.
I mean, we addressed this last month, both sides. We were going to move. Did we not talk about that?
It's exactly what we talked about last month, yes.
I mean, if in your opinion, it can't fly at 5, but it'll fly at 3, we'll accept a 3-foot setback, or a 3-foot.
But we made that abundantly clear last month. I'm not sure why you've brought it back. You're saying if it's our opinion, we made our opinion last month, and we gave you this month with deny without prejudice.
I did not design the plan. I was given.
Okay, thank you.
Okay.
What other questions do you have? Any other questions? Gentlemen?
No, sir. Thank you.
Any other questions? Again, is anyone else speaking on this in favor? Anyone opposed?
Hello, my name is Susan Reardon. My house is at 26 Field Court, directly to the west of their house. That was one of my questions, was the access to the house. The house as it stands right now is 5 feet 1/2 inch from the property line, as is my house. And all the lots down there are very narrow. We've owned our house for over 30 years. Before me, my mother had a house down there and my grandmother, so for over 70 years I've been in the neighborhood. Not one house down there has access on both sides of the house because it's so narrow, and to try and maintain a modicum of privacy, there's only been a door on one side of the house.
Not to interrupt you, but they did take away, ma'am.
The deck, they took away the deck.
On your side.
But they still have stairs going up and a landing. I was concerned how big that landing is going to be. All the other houses down there have either a door by the road or out to the front deck and one on the side, but not one house has an entrance on both sides of the house. And why this is particularly significant to us is that house provides the Rogers with a great deal of rental income. Sometimes people are there for a week, sometimes 2 weeks, sometimes just a weekend. And it provides them with a viewing platform directly into our house. So we are particularly concerned about them having any entrance on that side of the house where they could look into our windows. Everyone else down there has a door coming off the back by the road or one out to the water and only on one side of the house. The houses were all constructed so one side of the house is just 5 feet from the property line and the other side is wider to allow for a driveway or a car to park. So I'm just very concerned about our privacy, and they've demonstrated no hardship why they need a door on both sides of the house. They don't. They only need it on one. And as you pointed out last week, if they had one coming off the back of the house to the road, that would be their second entrance, and that would also be good for the bad weather, the cold weather, the wet weather. And that's my concern, is our privacy.
Mr. So, do you have a question for this lady?
Yes, could you clarify something? Did you say this is a rental house?
Pardon?
Is this a rental house?
They rent it, yes. There's a for rent sign out there constantly.
Huh, so they don't live there? Okay.
I think they're there when they're not renting it.
Okay.
They're there between renters.
Mr. Chairman, just
Yes.
as a point of clarification, when someone elevates their house in place, they're permitted the minimal stairway and landing. So when you see the landing and stairway on the west side of the house, they're allowed to have that. And as far as rental property goes, that's not an issue.
Correct. All right.
But no one else down there has entrances to their house on both sides. They either have it one side and then the front or the back, but not both sides because the lots are so narrow.
Thank you.
Thank you.
Are you speaking, sir? Are you in opposition? Yes.
Yes, very definitely. I got up when you asked for
Okay.
anyone to speak, and I let her speak.
Please identify yourself.
My name is Frank Rogers. I'm associated. I was involved in buying that house, I think 10 years ago or 15, something, whenever it was, a long time ago. Speaking to the mic. Is that better? The stairway on the left to that door is a wider door, and we need that width on that. We need that entrance over there to get heavy pieces in and out.
Now, is this your property? I'm talking.
It's my wife's property.
Well, I'm looking for people in opposition right now.
Oh, well, when do I have a chance to talk in
I asked before who else was in favor.
I stood up when in favor, but she stood up first, so can I not speak in favor?
Well, go ahead.
Pardon me, sir?
Yeah, go ahead. You're in favor, so We were just working on the opposition, and I thought you were opposing, so. And you said you didn't realize that she, so go ahead. If you're in
So
favor.
I want to show that, now, the other side, the other landing on the left, on the opposite side from them, that door is small anyhow to the outside. That's why we need to keep the one on the right. The door to the left is between the fireplace and the kitchen, and we can't make it any wider. So that we need that access over there. But I don't see. I know we have a stairwell there, and then we looking for 5 feet from the top of the landing of the stair to the front of the where the deck is proposed to be. My neighbor on the left has not opposed to that, and we've discussed that, and he has no problem with it. We reduced it from 6 feet to 5 feet. I like to have more than 3 feet, very narrow, from that short distance from the landing to the deck. I'd like to have you reconsider approving the plan as we have here. Now, we live a fair amount of the time down there, and it is true, we at times rent it too. You know, we're not as wealthy as our neighbors, so we just can't, we like the income to pay the heavy taxes and the heavy floodlands bill. So I'd appreciate your approving it as shown up here. Thank you.
Okay, thank you, sir. Is there anyone here opposed? Anyone else opposed? Mr. Crabtree.
I just want to reiterate that we legally can build the deck, and if we're denied the access, now Mrs. Rogers has a real problem, because now the only way she can get to a deck is if she wants to bring a ladder out there when she wants to have a party, have her friends go up there, and of course that's totally ridiculous. We think that under the circumstances that, contrary to some of the statements made earlier by the opposition, that our homes here, there's at least 4 of them, and I've detailed them in the packet there, that have had variances in the past to have access to the decks on both sides, and they're in the pictures. So I think that under the circumstances, we've attempted to be as good a neighbor as possible and ameliorate the concerns of the neighbor that has issues. If there are any other questions?
Thank you. Any questions? Yeah. Go ahead, Mr. Soto.
Mr. Crabtree, we're not saying to deny access to the deck, but a 5-foot deck all the way to the back deck is a little excessive for width when you're asking for a variance.
Well, I thought Mr. Rogers got up and explained the reason why they didn't want to reduce it any further, but again, the ultimate decision is going to be up to you.
5 feet is a little excessive, I think. You know, when you're asking for a variance to the property line, 3 feet is code. You could go 3.5 feet if you want a little bit bigger, but 3.5 feet's plenty.
I mean, ultimately, the decision is up to you. I would hope that we wouldn't have to come back to make an adjustment.
Hold
that
on.
the board could just reduce the variance.
I want to ask Mr. Harris a question, too. If we can come to some kind of decision on this, can we approve it with a condition?
Yes, you can condition, should you approve this, you can condition it in any way you see fit, as long as it relates to the project.
I mean, we can't increase the amount of variance requested, but it could be reduced to some lesser amount, and we wouldn't have to go back and send out the letters and come back a third time.
All right, go ahead, Mr. Haberman. You have a question?
Okay, thank you.
This hearing's closed. Okay. Okay, what are your thoughts?
Well, the right side is 3'6", and I think a nice compromise is 3'6" on the left side, and we do a conditional approval with 3'6" to the back deck. I think that's more than enough room.
The board question, and maybe he'll answer this. If they're moving appliances or furniture in and out of that house and they have to come up and move them in, is 3 feet wide enough to do that.
Well, he said that the door is too small there, so they need the door on the right side to move appliances. And
Okay,
he's got
so-
3'6" on the right side,
Okay.
so movers can get it in there.
All right, good.
You want to put that in the form of a motion, please?
Yes, I would like to make a motion to approve with the condition of 3'6" on the left side of the deck, all the way to the back of the house, and to move those stairs tight to the house.
Mr. Chairman, Mr. Soto means the east side.
Okay, the east.
Just to
Correction, the east side of the
clear.
house. The existing stairs will attach to the house without any space, and the walkway will be 3'6" to the outside, to the back deck.
You need a second?
Second.
Okay, we have a motion, and we have a second on the motion. Mr. Soto?
With the motion.
Mr. Vecino?
With the motion.
Mr. Haveman?
With motion.
Ms. Ferranti?
With the motion.
I'm with the motion, it's approved.
Thank you very much. Thank you.
Item number 6, 839 East Broadway, Zone R7.5. Melody Grant Bushy, owner, Section 4-1-4, north side yard projection to 5.4 feet, where 8 feet permitted to construct a deck for a single-family home, map 27, block 475, parcel 7.
Hi, I'm Melody Grant Bucci. I am the owner of 839 East Broadway, and looks like it's kind of cleared out here, so hopefully we don't have any parade coming in behind me, but I don't think so. I recently replaced an old deck on the back of my home and expanded on that and got appropriate permitting through planning and zoning. But the one piece that I'm holding off on with my contractor is putting an upper deck on my second level floor. I'm not exactly sure what paperwork you might have. I do have a photo if it would be helpful for you to take a look at as well.
We have a plan here, but if you have a photo and you'd like us to take a look at it, bring it forward, please.
Okay. I also have a letter attached there that my neighbor sent me this afternoon through email, so I figured I would submit that to you as well. So you can see from the house the deck work that has already been done. The upper deck, I'm required to put an upper deck in because my house is only about 1,300 square feet with a very narrow stairway upstairs, so to get mattresses, furniture, anything up, it's got to go through the upper doors. And during my original renovation process, I never went through the process to go ahead and to actually finish the home and put the second floor deck on. So that's what I'm coming to you for today. My setbacks on my side yard are currently 6 feet 19 inches to the south side and 5 feet 4 inches to the north side. So what I'm looking for is a variance from that 8-foot setback to have the deck actually be in line with the house from the south side to the north side, so to span the entire 19 feet of the house. And the projected distance away from the house is going to be 6 feet. So it's a fairly small deck, just enough to make it useful enough to be able to do what I need to do to move things up through the second floor entrance.
So your hardship is the way you would access to
Right,
get into
my
the house,
hardship
to get
is-
into the house if you you know, if you bring any kind of furniture in or appliances or
Right,
whatever.
that's the hardship, but the way, if I did the project and didn't come before you, then the pillar that would need to hold the deck and the upper deck would really obstruct. I'm waterfront property, so it would really obstruct, and it wouldn't be as attractive visually for the house either, so it would be, if I were to build the deck with the setbacks, there would be a pillar right in the middle of my first floor windows, and then a post on the second floor as well.
Any questions? Go ahead, Mr. Soto.
So this is just a balcony, there's no stairs up to it?
No stairs up to it, just a balcony. In fact, my original plan was I wanted to bring it all the way to the end of the deck and build a pergola out the walkway that's on the side there, and then I thought, you know, let me just scale it down and just go with just the basic upper deck and not do the wraparound and not come to you for a full variance all the way to the property line.
Any other questions? Go ahead.
And the balcony is not exceeding the width of the house?
No, it's not.
Okay. Anyone else speaking in favor? There's not a lot of people left here, but are you
there
speaking
isn't.
in favor? You can come up, put your name on the record that you're in favor. No? There's no one else behind you, but I'm asking if there's anyone opposed. Anyone opposed to this application? Okay, this hearing's closed. What do you think? One of our more simpler ones.
Yeah, I don't have a problem with this, I mean.
Okay. There's no stairs, it's just it's fine. I think so. Motion?
Make a
Mr.
motion to
Ferranti, you wanna
approve.
Make a motion?
Second.
They already beat you to it. Who made the motion?
I did.
John Bacino. We have a motion to approve, and we have a second on the motion.
We're not increasing the nonconformities and follow the site plan that was submitted to us today for the balcony,
Okay?
with the hardship being the noted narrowness of the lot.
Vote, please. Mr. Soto?
With the motion.
Mr. Vazino?
With the motion.
Mr. Haberman?
With the motion.
Ms. Ferranti?
With the motion.
I'm with the motion. It's approved. Okay. New business. What do we have for new business? Anything? Any staff updates? We need a motion to accept the minutes from our April meeting, April 12th. Motion, please.
Motion made, accept the minutes as read.
All in favor? Aye.
Aye.
Opposed? None? Okay. Acceptance of applications for our June meeting. We have just one that was tabled. Possibly that'll be back, or maybe we'll have only a few next month. Motion to adjourn.
Make a motion to adjourn.
Second.
This meeting is adjourned. Thank you.